In a 3-2 decision today, a New York appellate court ruled that Donald Trump, the president, is not immune from a civil defamation suit just because he's president. Trump had tried to block or even delay the litigation, claiming he can't be sued in a state court while he's in office. However, the court rejected that Trumpian argument, stating, though he is tasked with significant responsibilities, the president is still a person, and he is not above the law. Do you like that? The suit was filed in 2017 by Summer Zervos, remember her, a former contestant on The Apprentice, who alleges that Trump engaged in inappropriate sexual behavior toward her on 2 occasions. Here's how she described one of those advances by Trump in a 2016 press conference.
He put me in an embrace, and I tried to push him away. I pushed his chest to put space between us, and I said, "Come on, man, get real." He repeated my words back to me, "Get real," as he began thrusting his genitals. He tried to kiss me again with my hand still on his chest, and I said, "Dude, you're tripping right now," attempting to make it clear I was not interested.
Well, Zervos filed the defamation suit after the president called her and other accusers liars. That was his words, among other things. Here he goes.
The stories are total fiction. They're 100% made up. They never happened. They never would happen. These are lies being pushed by the media and the Clinton campaign to try and keep their grip on our country. They are all false. They're totally invented, fiction, all 100% totally and completely fabricated.
Well, in ruling against the president, the court today drew a direct comparison to Paula Jones's 1994 lawsuit against President Clinton, saying the plaintiff's case is materially indistinguishable from Clinton versus Jones. Well, Trump's lawyer says the president will appeal the decision. I'm joined now by Katie Fang, MSNBC legal contributor, and Glenn Kirshner. Both of you know what you're talking about. I don't hear. How much is this like President Clinton when he had to defend himself in a deposition which got him into all kinds of trouble back in the 90s? Katie.
So this is a spectacular decision that came out today. As you said, it was a 3-2 decision, so it wasn't unanimous, Chris. But think about this. There's actual language in this holding today from the appellate court in New York that says the presidency and the president are indeed separable. And so now Donald Trump has to face the music in a state court brought by Summer Zervos in a defamation action. And that means that the discovery process, which has not had the brakes put on it thus far, is going to continue. And like you just said, there is the potential that a deposition will be taken of Donald Trump, and he will have to answer under oath.
Glenn?
So, Chris,
is this going to be a case where Trump's on television and some tapes running, videotape, and the prosecutor says, I heard you on that Access Hollywood tape. How many times in your life have you acted on that thinking that you can get away with grabbing people wherever you want?
Oh, yeah, Katie's right. Discovery is going to be wide open. When he sits for a sworn deposition, he's in a lot of trouble because it's a no-holds-barred process.
Anything like the sexual misconduct she accused him of is fair game.
Absolutely. So here's just to break down what the New York Supreme Court said. A little bit of a misnomer because the Supreme Court is an intermediate level court. Right, then you go up to the New York Court of Appeals. So
they didn't study grammar in New York. Go ahead.
But here's what they said. The Supremacy Clause of the Constitution says if there's a federal law and a state law, and they conflict with each other, the federal law wins because the federal court is supreme. The court went on to say, the New York court, there is no federal law that says you can't drag a sitting president into court in a civil suit and make him account for himself. So the Supremacy Clause doesn't bar this kind of suit. Here's what I wrote this down because I love this language from the opinion. It said the court said nothing in the Supremacy Clause of the U.S. Constitution even suggests that the president cannot be called to account before a state court for wrongful conduct. You know what we're doing? We're chipping away at the president is king misbelief.
Good. I'm glad we are, because we did it under Bill Clinton. Let me get back to that with Katie. I rely on you for this. Bill Clinton got in trouble because Ken Starr was out to get him. But Ken Starr had some opportunities here, which Bill Clinton's behavior gave him, which he had apparently engaged in misconduct with Paula Jones when he was governor. Okay, they brought him in on that one, which is some level of misbehavior, which is pretty gross. But they were able to ask him all about Monica Lewinsky, got him into a perjury situation. Go ahead.
That's right.
Is this what we're going to see again here?
So you have to tell the truth when you're under oath. I know that is a little bit of a stretch for somebody like Donald Trump, but when you're sitting there and you take the same oath that you and I would take if we had to sit for a deposition, and you basically lie, you commit perjury. And so because it's open season in terms of the discovery, in terms of the deposition questioning, the key difference is when Donald Trump was answering questions to the Mueller team, those were written answers to written questions. So Donald Trump's legal team vetted all of those answers. There was nothing that went back to Mueller that had not been reviewed carefully time and time again by his lawyers. This is a different situation. You got Donald Trump likely in a videotaped deposition setting. He's answering questions. He's going to be unhinged. You're not going to be able to rein him in, and he's going to say what he wants to say. Okay,
Trump is crazy like a fox sometimes. Suppose he says, I'm not going to listen to a lawyer like Bob Bennett that Bill Clinton listened to. I'm going to say this. I'm president of the United States. I'm not doing a deposition. I'm not going to go into a perjury trap. Make me. What happens? Suppose he just says, I'm president. You come get me. I work at the White House, 1600 Pennsylvania. You send the cops to get me. Go ahead, try it. What happens if Trump just does? Because I think that's a smarter move, as outrageous as it sounds, than going in there and lying on tape. Your thoughts, Katie?
Well, so that's
he says,
a very
no, I'm not
interesting
going to
point,
do
Chris.
that.
Well, yeah, and actually this opinion that was issued today addresses the issue of whether or not contempt of court can be applied to somebody like Donald Trump. But what's fascinating about this opinion is, and this will address your question, Chris, can you believe that the actual opinion today cites Supreme Court Justice Brett Kavanaugh. Brett Kavanaugh actually had a Minnesota Law Review article years ago that said if Congress wanted to protect the president from this type of litigation, they should pass a law. Congress has never passed a law. And so as a result of that, Donald Trump trying to sit there and deny the access that the plaintiff, Summer Zervos, has in this case is wrong, and he would be held accountable for it.
He was channeling Antonin Scalia there, because Scalia believed, I heard him say it to a private conversation, I interviewed one time off the record. He says, I like legislation. Pass a law. Don't intuit it.
Yeah.
But back to my question, Katie, suppose he says to his people around him, I'm not going to sit in some room on camera and lie.
Then what happens is the plaintiff in the case goes to a judge, gets an order directing him to answer questions in the deposition, and if he doesn't, then he is subjected to contempt.
And then what happens?
And
Keep
then
going here.
Then we have to fight the battle of whether a state can hold a sitting president.
Are they going to send the gendarmes to Washington to get him?
They could impose civil penalties. They could perhaps even jail him. I know.
But isn't Trump smarter not to lie under oath?
I don't think Trump is all that smart.
Well,
Chris.
I'm asking.
No.
I'm speculating. Katie, you're shaking your head. Is Trump smart to lie under oath or shut up? What's the smart move? If he has to.
He's lied under oath in previous depositions. And so if history is any indication of present day events, he's going to lie when he's got to do it. And listen, Chris, the discovery cutoff is happening really soon. All party and non-party depositions have to be concluded by June 28th, 2019. That's very soon. And so we will see whether or not that deposition happens or not within the next few months.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.